Very senior lawyers, legal experts, friends and family of the 22nd Chief Justice of Nigeria, Justice Olukayode Ariwoola, are in this hall for a valedictory court session in his honor. The full complement of justices of the Apex Court are also here to witness the ceremony.
Better heights in life.
The Attorney General of the Federation and Minister of Justice kickstarts the session with an assurance of the federal government's support to the judiciary and its resolve to ameliorate the sufferings of Nigerians.
Nigeria's justice sector shall continue to witness several massive turnarounds, initiatives and projects that will restore, transform and reposition our justice sector and place it as the best in the global legal community.
Lending their voices, the Nigerian Bar Association and the body of benchers extol the virtues of Justice Ariwoola.
We appreciate the grace of God upon the life of my Lord, the Honorable Justice Olukayode Ariwoola, for seeing his lordship through an illustrious career on the bench and as Chief Justice of Nigeria.
My Lord Justice Ariwoola is a very good parent, a parent who cares about his children, about their career, about their future, about the generations yet unborn.
In his valedictory speech, the outgoing Chief Justice of Nigeria laments the overburdening of the Apex Court.
My noble lords, it is however my belief that access to justice should not be regarded as uncontrolled and unfiltered liberty to bring all forms of cases to the Supreme Court. It is my belief that we trivialize the institution of the Supreme Court as a court of policy when every form of litigation is able to meander its way to the Apex Court.
He also bemoans the long delay in the adjudication of cases owing to inadequate judicial officers.
It is my conviction that the right to fair hearing enshrined in the Constitution of the Federal Republic of Nigeria could only be meaningful when litigants have enough judges and justices to hear their cases. Justice is not a scarce commodity to be queued for. Justice without delay is inherent, natural, and constitutional.
The immediate past Chief Justice of Nigeria, who was born on the 22nd of August 1954, was elevated to the Supreme Court bench in November 2011 and appointed the Chief Justice of Nigeria in June 2022, following the resignation of Justice Tanko Mohammed. He will be succeeded by Justice Kudirat Kekereekun.
And that's what we'll be looking at today, the judiciary. I mean, as someone will say, one main man steps out, another main man, now a main woman, stepping in soon. But that's our conversation today, and we have joining us a senior advocate of Nigeria. He joins us virtually, Mr. Kunle Edu. Thank you for joining us this morning.
Good morning, Mr. Nyota. Please let me make that correction. I'm not after 30 September, after the conferment ceremony. That is when I will rightly be referred to as the senior advocate of Nigeria. For now, I am Kunle Edu, Esquire.
Okay, soon to be senior advocate of Nigeria. All right, let's get into this real quick. What that valedictory session yesterday and the statement made by the outgone Chief Justice of Nigeria, he made one statement that stood out above all: the burden on the Supreme Court. He says there are some cases that shouldn't even get there, and I'm sure this is not the first time you've heard this, but let's hear your point of view from that angle.
Nyota, I think this is one time that we should commend the outgone CJN, my Lord Honorable Justice Olukayode Ariwoola. His tenure, though brief, has been very, very eventful. We actually recall that within the last 2-3 years or thereabouts, we've had some new life, infused into the judiciary. What am I saying? During his tenure, we have the trial court, the trial judges of the High Court, Federal High Court, National Industrial Courts. we have their tenure, which hitherto was 65 years, now being extended to 70 years. That is, they have up to 70 years before they can retire, of their age, before they can retire. We also are aware very well that during the tenure of my lord that I just retired, that we have been talking for a very long time about the issue of salaries and remuneration of the judicial officers. Very, very appalling. Good enough with my lord's intervention, working with the Attorney General of the Federation, we have seen that done. And only a few days ago, the President of the Federal Republic of Nigeria did assent to that particular bill that enabled this improved salary structure to be implemented. And we also are aware very well that on the issue of injunction, conflicting orders here and there, my lord actually in several instances intervened, and I don't think that is news any longer, the issue of conflicting injunctions. So by and large, I think these are just some of the few that I can remember very well that my lord Ariwola did initiate and ended. And I can also recall very well that the issue of, for the very first time in the history of the Supreme Court of Nigeria, we've had the full complements. Have the full complement of the Supreme Court justices, full 21, as spelled out in the Supreme Court Act for the first time. And with that, we are now saying, because I practice before this, I appear before them regularly, we are now seeing appeals now moving very, very fast, unlike what it used to be, where appeals will spend 15 years, 20 years at the Supreme Court. Now, they are now, all the old appeals are now being attended to because we have several panels now sitting on a particular day. So that is kudos to my lord Ariwola. By and large, I listened to his valedictory speech. He has done much, but there's still more to be done. And that was what was actually espoused in his valedictory speech. My lord is still expressed the minds of many lawyers and Nigerians with regards to the judiciary as it is today. The judiciary still needs to be better structured. It still needs to be better structured. My lord Ariwola has done his part. And I use upon it to also welcome my lord, Honorable Justice Kudirat Kekereekun. My lord is a square peg in a round hole, incorruptible. And I believe that all Nigerians will be very, very happy seeing my lord ascending to the office of the high office of the CGN of Nigeria. Many good things are going to happen within the next few days, next few months and years, with the coming in of my lord, Honorable Justice Kudirat Kekereekun. Now, my lord, the CGN actually complained about the Supreme Court being overburdened. I, as one person that regularly practices before the Supreme Court, I can confirm that. It is actually overburdened. It will shock Nigerians to know that cases from small claims courts, like magistrate courts, customary courts, at times they end up at the Supreme Courts. I try to wonder why should it be so. But the frank truth is that there's no law that forbids such appeals going straight to the Supreme Court if the leave of the court is sought.
Mr. If I may come in here, when you have allowed you to run through to make your submissions as regards the event yesterday and your commendations for Justice Ariwola, who's retired now. But when you get to that point, I actually wrote down here in terms of what reforms should we be looking at coming from the judiciary. Among some of the things that Nigerians complain about is what you just mentioned, the fact that cases from small claims court, as you call them, get up to the Supreme Court, which shouldn't be. But there is the other part of courts of competent jurisdiction giving about the same rulings of judgment as the case may be. You get to a federal high court sitting in Abuja, it rules on the same matter. You go to a federal high court sitting in, maybe, for want of a better example, in Kaduna, sitting on the same matter and giving conflicting judgments. What do we do about that? Because that is painting a not so good picture of the judiciary.
Thank you very much. I seem to be having some audio problem. If you could repeat the last three lines, please.
where courts of competent jurisdictions, courts at the same level, sitting in different locations, give counteracting judgment over the same matter?
Thank you very much. This brings to my quick recollection the emirship Tozo in Kano State. Very, very unfortunate. And I think all of us are worried. The bar and the bench, we are very, very worried. On the subject matter.
Well, it looks like Mr. Dune's having some technical issues there, but hopefully we'll have him back so that he could weigh in on that matter. But Ayo, I know you're there. Okay, he's back.
That the judiciary needs to have this conflicting decisions from courts. Yeah, actually, I call it more of a competition. I don't know why the High Courts and the Federal Courts will be competing with each other with respect to a particular subject matter, when the Constitution of the Federal Republic of Nigeria has actually spelled out their respective subject matter jurisdiction. And there are a lot of Supreme Court authorities, actually decisions, that actually further espouse the distinct subject matter jurisdictions of these various courts. And I believe this is when the NJC itself needs to also step in. Because until we start dealing with this issue, and probably after investigation, any judicial instantly, that it will act as a deterrent against future cases. Until that is done, I am afraid we're going to see more of that. But I think with the experience, with the privileged information that I have about my Lord, the CJN, Honorable Justice Kudirat Kekereekun, I think I strongly believe that my Lord is going to attend to this issue. I strongly believe that, and it may be a thing of the past in the next few months, next few years, as the case may be, because I trust in my Lord, the present CJN, that my Lord will deal with it. Working with the NJC, my Lord is the chairman of the NJC. The NJC, we now have to be more proactive in dealing with these situations, because if we fail to deal with it, it may lead to anarchy. The Nigerians today, the confidence they have in the judiciary is shaky, very, very shaky. And this is the reason why we are having NSAS protests here and there.
So, Mr. Dune, we're having Mr. Dune coming back and forth. The network there is not too fantastic. Mr. Dune, can you hear me? Okay, we lost you there. We lost you there for a bit. So if you could just step back a bit. You were talking about the fact that the incoming Chief Justice of Nigeria is actually the chairman of the NJC. We know that. But how quickly does the NJC act on these matters of conflicts where the same courts in different locations are ruling on the same matter, giving conflicting judgments? And it's not, again, Nigerians are weary. Those litigants are, both the lawyers and those who are seeking redress, are confused, wondering what to do. There are cases at the moment that we're still trying to get clarification on.
Thank you very much. I can only say that the NJC will need to be more proactive. Much has not been done, truly. Much has not been done. Like I did say, the confidence of Nigerians in the judiciary is very, very shaky, very, very shaky. And it's only the NJC and my Lord at the CGN that can bring back that confidence. Situations where petitions are written against judicial officers, I think they should be given accelerated, in an accelerated form, because if you write a petition against a judicial officer, it takes 6 months, 1 year, nothing is done. I mean, the petitioners may go home with the mindset that, it has happened again. But I don't think it works that way. However, the agency needs to do more. They need to do more in terms of disciplining judicial officers. It is very, very critical. Because if they don't do that, more judges, more judicial officers that may want to toe the line of being corrupt, committing misconduct or judicial misconduct on the bench, will continue. It's only going to get worse. So the only way we can address that issue is for the agency to bring in the hammer when necessary, because I know that there are some frivolous petitions against some judges. But what we are trying to say is that let there be fair hearing, and let the fair hearing be done in a very, very quick manner, so that everybody will be confident, will be assured that, oh, NJC has actually stepped in. Probably the NJC may need to give itself some timeline in attending to petitions. And also, Nota, it doesn't only lie with the NJC. We lawyers at the bar too, we should also call ourselves to order, because the judges, they don't bring cases to their courts. It is we lawyers that fight these cases. That fight these cases in a situation where a lawyer knows very well that a court of coordinate jurisdiction has already attended to that matter or similar matter. Why go and fight the same case or similar case in another court? That obviously is a professional misconduct. So it is in this wise that I would urge the NBA and the LPDC to also sit up. They also sit up in a situation where the LPDC and NBA, they are aware, or by way of information, because now we live in a social media world. They are aware. Well, I don't think we need to be waiting for petitions. Probably we need, the NBA itself needs to appoint a sort of inspector general. It's an inspector general to monitor issues that have to do with misconduct amongst lawyers. Because some persons may not want to petition either by way, probably because they are afraid or some other reason. But the misconduct, the mess has been done, and it is tarnishing the image of the legal profession and the judiciary. So both the LPDC and the NJC, and of course I will include the NBA, we need to do more than what we are doing, because justice is what the common man needs. Without justice, we are seeing what is happening. The protests here and there, NSAS protests here and there. The last time when NSAS happened, some of the courts were burnt down. What does that tell us? That the common man is not yet satisfied with the justice delivery system in this country. So I may go to say again that this is a good time that my Lord Kekereekun has stepped in. My Lord Ariwola has done his best, and we give him kudos. And continue from that same legacy. My Lord Kekereekun has come in, and I believe that more will be done. The NBA that I believe the incoming president, Mazi Alpha Mosigwe, SCN, and his ESCO, and I believe that they will also ensure that this issue of professional misconduct by lawyers, taking cases before similar courts, disgracing the legal profession, it will be a thing of the past. I am very, very sure of that. However, sir, Nota, if I may continue, the issue of subject matter jurisdiction, that all the cases from small claims court end up at the Supreme Court, I think it requires constitutional intervention by way of amendments. Because the Constitution as it is now actually allows every Tom, Dick, and Harry to take every case, assault, stealing of 1 naira, 2 naira, small stores, end up at the Supreme Court. We cannot continue like that. Matters that have to do with states, should end at the Court of Appeal, or if it is allowed, they can create a state Court of Appeal as it operates in the US. But only very, very important matters should end up at the Supreme Court. Constitutional matters, fundamental right matters, matters that have to do with capital offenses, treason, those ones they can end up at the Supreme Court. And with regards to also the issue of electoral matters, why should House of Assembly, House of Rep, or even a governorship in terms of pre-electoral matters, why should they go to the Supreme Court? I think the Supreme Court is very, very well overburdened. So we need the National Assembly working with the NBA and, of course, the NJC and the NJI to get around this and unbundle the Supreme Court, so that only critical matters that affect the nation should end up at the Supreme Court. So,
Mr. Adun, you see, this suggestion you talked about now, constitutional amendments to see that subject matter jurisdiction is looked at critically. Some will argue that there are a lot of lawyers sitting in the National Assembly as we speak who are members of the bar and have gone through the process and all of that. Indeed, the president of the Senate is a lawyer. So if the lawyers who are in the National Assembly have not thought about this, to say, okay, it's time to look at this aspect of our Constitution so that the courts themselves are not overstretched and overburdened. We've looked at the remuneration for the judicial officers and the judges. Maybe that part also needs to be looked at again real quick. But when you say that amendment. How quickly do we see that amendment happening? If you earlier you talked about the NJC being more proactive. In what sense, when you say being more proactive, in what sense would you want that to be? How do we begin to go? Someone will say the question of consequence management, so that if the judge errs, the judge is punished instantly. And if the judge does good, the judge is rewarded instantly by the regulatory body, which is the NJC. Is that the kind of being proactive you're talking about?
Yes, that was what I said. There should be timelines for treating petitions, probably max 6 months to treat petitions against judges. 6 months is a reasonable time. But when it goes beyond 1 year, 2 years, 3 years, the petitioners will of course, they will lose confidence. Now, on the issue of how, lawyers in the National Assembly, how they can partner with the NBA and other stakeholders, critical stakeholders, in terms of constitutional amendment. I want to tell you here that the NBA has, before now, I recall when I was National Political Secretary under Kolusoro SCN, we set up a committee working with SPIDEL, that is the NBA section of Public Interest and Development Law. We set up a committee to come up with areas of the Constitution that we think actually need amendment, but with particular reference to the judiciary, reforming the judiciary. We came up with a very, very fantastic report. There were a lot of good recommendations, and the NBA president then presented it to the then Honorable Attorney General, if I can still recollect. So the documents are still there. Nevertheless, it's a continuum. I'm saying it's a continuum. So the NBA can still do the same, working with the NJI, that is the National Judicial Institute, working also with the NJC. They can also set up a tripartite committee on this and come up with very, very laudable areas for reform, and working also and present it to the committees in both the House of Rep and the Senate for judiciary and legal matters. Present it to them, because lawyers, they are also lawyers. So, and I want to tell you that even when the present Senate Majority Leader, Bamidele was there, we actually worked with him. The NBA actually worked with him, and he's still there, so he can still work with. He was the chairman of the Senate Committee on Judiciary and Legal Matters. We worked with him, and he was very well ready to cooperate with us. So the question is that have we actually taken those steps? If we have not, I think this is the best time to take the step. The NJC, the NGI, and the NBA. They should come up together, have one single committee, not separate committees working at cross purposes. Come together, come up with resolutions, recommendations, and meet the Senate Committee on Judiciary and Legal Matters and the House of Rep committees, you understand, so that they come up with a joint resolution on this issue, joint recommendation on this issue, and present to the National Assembly Committee on Constitutional Amendments. In that wise, it should already be an easy sale if we can get the full cooperation of our members in the National Assembly, and I think they are there to help. Nevertheless, our members in the National Assembly should also see, because they are first and foremost lawyers. So the interest of justice should always be primary to them. It should. So they should also be interested. So they can also reach out to the NBA. They can also reach out to the NJC, reach out to the NJI, because all of us, we have a common interest. What is the common interest? Let there be a sustainable justice delivery system that the whole world will be proud of. That investors coming to Nigeria will say, oh, we can go to Nigeria and invest, because the justice system is as good as in any European country. You understand? And let it also be that when somebody knows that he's charged before courts, within 1 year, 2 years, the matter is through with. Not 5 years, 10 years. I have a case that is still at the High Court for almost 15 years now. Almost 15 years. 15 years now. Almost 15 years. 15 years now. Almost 15 years. 15 years.
I mean, you've made quite some, strong points there, but to the issue you spoke about concerning the opinion of the outgone CJN about the Supreme Court being overburdened, do you think we need adjustments to some laws in order at least to put some force of law behind people, not all cases not getting to the Supreme Court? Do you think there's any adjustment to some laws necessary?
Suggesting that should be done is we need to tinker with the constitutional provisions that confer adjudicatory powers on the Supreme Court to hear appeals from like almost all the courts in Nigeria, which to me I look at, no, it can be. So we need a constitutional amendment in that regard. Pre-election, this is my personal opinion, pre-election matters should actually not go before the Supreme Court. With due respect to my colleagues that may want to hold contrary views, all pre-election matters, including presidential, should not go before the Supreme Court. For crying out loud, you have not been elected now. So what should be your business taking a pre-election matter to the Supreme Court? So pre-election matters with regard to the presidential primaries, gubernatorial primaries, should actually end at the Court of Appeal. Then with regards to other primaries, then of course the High Court should be the court of trial and the final court, because they are just pre-election matters. Then with regards to post-election matters, of course, probably we may need to go back to the situation we had before, where it is only presidential elections that should actually be held by the Supreme Court. Gubernatorial elections should end at the Court of Appeal. You know what, sir? The Court of Appeal, because we have several, I think more than 12 or 13 or 14 judicial divisions. These are more or less like zonal courts or regional courts. So if a state has there are issues with regards to a state's gubernatorial election, for crying out loud, after going through the tribunal, then end up at the Court of Appeal, which is a regional court, somehow, instead of going to the Supreme Court to go and overbody my laws that are there. So that is one. Now, another one, sir, is that land matters. Land matters have no business going to the Supreme Court. Because, to be frank with you, sir, all the issues, principles of law regarding land matters, they are long oversettled. So there's nothing new that will be brought to the table by the Supreme Court or any other. In fact, in most cases, the Supreme Court actually restates previous decisions and principles on land matters. Then matters that have to do with torts, assaults, some simple civil claims or contracts. They have no business going to the Supreme Court. They should end at the Court of Appeal. Criminal charges that have nothing, that are not related to capital offenses. Capital offenses in this wise are cases that, like murder, like in some jurisdiction. I don't know. Probably I think one or two states. Probably okay. I would have loved to include cases where life imprisonment is the maximum.
Giving some counsel to the NBA. I think you're already giving some counsel to the NBA, to the NJC, and even to the CJN to make this adjustment. So, which is a good thing, and thankfully you are coming in as SAN. So, hey, let's say you got your job cut out for you as well. But how about insulating? How do we insulate the judges or justices from corruptibility? Because the reason that people will take one case from one level to the other, to the other, to the other, is because they do not believe that, the first court did justice, so they appealed it. And then they didn't think that maybe the other, case was the other court, the appellate court, was also not satisfactory, so they take it higher, on and on and on like that. So, and sometimes some people have also alleged that some courts in Nigeria have become, a place where you go shopping, and it always goes to the highest bidder. How do we insulate the judiciary, particularly the judges and justices, from corruptibility?
Thank you, my dear brother. Not all judges are corrupt. I think it's just the few bad eggs that are actually tarnishing the image of the majority. Because I have had courts, a lawyer must not win on his cases. This is my personal experience. I've had courts in certain situations where probably my cases did not go the right way. I lost. the clients will now say, is it not possible that probably the other side bribe? No, I said I would not know. I would not know. And by the way, I am not one of those persons that start going around and tarnishing the image of judges that it's possible that he was bribed or whatever. No, if you are aggrieved with the decision of a court, you go to the Court of Appeal. That's why we have the Court of Appeal there. Except you have clear evidence of corruption, then I think it would be unfair to rub on all the judges the same use the same brush. No, it is very, very unfair. However, I must also admit the fact that there are still some modicum of corruption on the bench. I must admit that fact. And when we are talking about corruption doesn't necessarily entail monetary considerations, giving money, sort of stuff. No, corruption is a very wide word. It's a very, very wide word. I could be, me as a judge, I could be related to somebody on the basis of that, on due influence. I could deliver injustice rather than justice. That is a form of corruption. Now, going back to your question, how do we insulate judicial officers from corrupt tendencies? Good. The NBA, of which I am a part, I'm a critical stakeholder, we also need to also monitor how our colleagues conduct their cases. If the NBA, as a matter of fact, is aware of any information regarding whether a lawyer has bribed or whatever, the NBA should on its own take it off. Because if the NBA doesn't take it off, that same brush will be used on all of us. You understand? And of course, the bench, because it is not, like I said earlier, it's not the judges that bring the cases to the court. It is we same lawyers that take these cases to the court. So the bench, as a matter of fact, and very, very important, I'm saying this with all respect, due respect to my laws, should avoid anything that will have to do with relating with the politicians. I'm aware of the admonition of a Supreme Court justice. I can't recall the name now. I think Obaseki, retired. May God bless him. He admonished judicial officers, please run away from politicians. They will tarnish your image, because it's possible that a judge may attend the occasion, let's say ceremony or whichever event, organized by a public servant, who obviously is a politician. Seeing the judge and the politician alone may give this, may make Nigerians to insinuate, did I not say so? They have bribed them, which may not necessarily be so. Right. What I'm trying to say is that when justice is done, let justice be seen to be done, manifestly seen to be done. Anything that may give the impression that a judge has been compromised, our judicial officers must avoid it. All right, let the politicians be.
Yeah. Well, how about that other issue that you raised about legal practitioners, lawyers such as yourself and your colleagues, who, as you said, are the ones who take the cases to court, and they know from all available whatever that, hey, this case is not likely to go in a particular direction, yet they take those cases to court anyway. So in terms of, and that's among other issues, in terms of discipline, in terms of deterrence, from lawmakers, legal practitioners overburdening the courts with cases that really shouldn't go higher, what would be your counsel? Is there any kind of deterrence for legal practitioners not to take certain cases to levels where they know they really, really don't need to get to?
Thank you once again. Actually, it's an act of professional misconduct for a counsel, knowing very well that the facts of the case as presented to him would not necessarily constitute a valid claim or actionable claim in court. It's an act of professional misconduct for such a counsel to advise that litigation should be commenced. And there are ways we can deal with situations like that. And one of the ways is the legal disciplinary committee. And we also have We also have the General Council of the Bar, which enacted the rules of professional conduct, of which I'm a member of the General Council of the Bar. Now, the ROPC provisions are there for all lawyers and all Nigerians. You can actually find it if you Google it, rules of professional conduct. You can Google it, and it will be there to guide all Nigerians, all litigants, and all lawyers, so that whenever there is a situation where you see the case is obviously not one that should be brought to court. There's nothing wrong if the opposite counsel petitions that lawyer. There's nothing wrong with it. But provided that petition is not frivolous. So you must be very, very sure that the action is not actionable, but it's something that the lawyer shouldn't have filed. Because if we don't do that, it actually clogs the dockets of the courts. A court that ordinarily should be dealing with 4 or 5 cases on a particular day will now be dealing with 20 cases, 25 cases, one judge. So it doesn't help the system. So we the lawyers, we need to also help the system. And of course, I will also use this opportunity to also urge my lords, my noble lords, that when cases like that come before them, they should just refer the case straight to the multi-door, instead of clogging the dockets of the court. Refer the case to the multi-door. So, colleagues, please, this is the kind of case that I think should refer to the multi-door, because I think the matter is so simple that it can be resolved. You know, there are ways you can express the judges can express this to the lawyers without being seen to be taking sides. So refer them to the multi-door. That is when obviously on the face of the case, there is no actionable claim. So NPDC is there. The judges can also intervene, refer the matter to the multi-door. And of course, judges also we lawyers we are ministers in the temple of justice, and the judges also, they are our lords. So even in the open courts, there are some judges that do it in the open courts, right there, even on first mention of the case. The judge said, what is this case about? So getting the facts, everything blown out in the open court, the judge may just say, no, I don't think, this is the way we should go. So judges should also be proactive in doing that. That is, I call it ADRO inside the court.
All right, a quick
cases,
one.
From judges in Delta States, they do that. Many cases have been resolved that way. So in that way, we now decongest the dockets.
Okay. All right. How about this last one? Two in one, actually, and you have just about a minute or two to deal with this one. 2 things in one. Number one, do you think judges are paid well enough? Number 2, do you think we have enough courts?
I have seen the improved salary structure of judges. We thank the outgone CGN and the AGF and our president for making it possible, but I still think that more needs to be done. The job of a judicial officer is not easy. Imagine a judge handling a matter, 25 cases is docket every day. It is killing. And of course, we need to also take care of their health, because some of them, they have health issues arising from workplace inconveniences. So, in terms of other allowances, their vehicles we need to change their vehicles, get them good vehicles. And let me use opportunity, please. Because a few days ago, one of the states in the north, the vehicles were presented to judges, and it's like all the media houses, social media, we are agog with the news. I think we should stop that. We don't see that happening when the legislature, the House of Assembly members, and when the executives, when they buy vehicles for themselves, please, they should not tarnish the image of the judiciary. And there's financial autonomy. Why don't you just give the money to the judiciary? They know where to get all these vehicles for themselves instead of advertising it. No, it is not something that we should encourage, and I pray that they put a stop to it. Now, we have enough costs. I don't think we have enough costs. We don't. Because the same costs that we have been using in the last 20, 30 years, they are still the same costs we are using. So we need to build more cost structures. We need to build more costs. We need to also devolve the kind of cases that go to the Supreme Court, that go to the Court of Appeal, and that even go to the High Court. There are some small claims that can actually be handled by customary courts, area courts, and magistrate courts, Sharia courts. They don't even need to go to the High Court. And I also use the opportunity to also encourage our colleagues to also deploy ADR strategies in resolving their matter. It is not all cases that must go to court. It is not. There are some matters that people counsel to counsel, exchanging correspondence, they can easily settle.
Now, how about the place of technology in all of this? You have 30 seconds for this.
Yeah, thank you very much.
In the judicial process.
I must commend my Lord Ariwola because where he just signed out the new Supreme Court rules 2024, and technology was also considered. Now there are going to be virtual filings at the Supreme Court. In terms of communication of dates, hearing dates, everything is going to be virtual now. So that is a good step. Now, many of our courts, even at the Court of Appeal, at the appellate courts, they don't even have recorders, electronic recorders.
You know, I asked this question, Mr. Edu. My apologies. I asked this question because I know that it's a long conversation, and at least I'm glad that someone is thinking about it. And I also hope that our laws will cover a situation where somebody goes in this virtual representation and all. Someone goes and represents an AI goes and represents Kunle Edu and says, I am Kunle Edu. I don't know if our laws cover that one. Please don't answer that one yet. Thank you so much for your time this morning. Mr. Kunle Edu is a senior advocate of Nigeria designate. Thank you so much again for your time.
Please, sir.
I said you are a senior advocate designate. Senior advocate designate. That's what I said.
Thank you, sir. Thank you, sir.
Thank you so much for your time. So, Business Morning on Sunrise Daily is next. In it.